Ms. Miller, we're going to have you come right to the podium here. People versus Alexis Miller, case number 234787. The record should reflect Ms. Miller's present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Ziegler appearing on behalf of Ms. Miller.
Thank you. This is the date and time set for a sentencing hearing in this case today. Ms. Miller, have you had a chance to go through the pre-sentence report and you talk to Mr. Seeger about that? Mr. Seeger, are there any additions, deletions, or corrections?
Your Honor, there's only one, and I did have an opportunity to speak with the Department of Corrections yesterday, and I think it was me. But in page 2 of the under the recommendation narrative, it says that the guidelines are 2 to 17 months, but if the court flips over to the actual scoring guidelines, they're 0 to 17. So I believe that the correct number should be 0 to 17, not 2 to 17.
Mr. Ziegler, any objection?
No, Your Honor.
Okay, we'll amend the report to reflect the guidelines are 0 to 17. Any other changes?
Oh yeah.
Are there any challenges to the scoring of the guidelines?
Oh yeah.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for application?
Your Honor, I think I agree pretty much entirely with the report as drafted. The guidelines of 0 to 17. I agree with the author of the report. The defendant has had a bad attitude. She's hesitating about taking responsibility. Even in the defendant's description of the offense, she advised that she was simply in the wrong place at the wrong time. I don't believe that. Her criminal history does not really recommend her for a probationary sentence. She does have 5 prior felonies. For all those reasons, Your Honor, I agree with the recommendation that jail is appropriate. There was an agreement for a county cap in this case. I would say that that's, if the court wanted to sentence to 12 months, I think that would be more than appropriate. Otherwise, I would ask the court to sentence this defendant somewhere in the middle of the guidelines. I don't see any reason why the court would move too much from the middle of the guidelines in this case.
Thank you, Mr. Seeger.
And I recognize that Ms. Miller does come before the court with a prior criminal history, and she clearly pled guilty in this case, and at times she has been difficult to communicate with. But I think that she struggles a lot with a lot of things that happened to her when she was younger. I remember Ms. Miller when I was handling her case somewhat indirectly through the neglect and abuse arena, wherein she was in foster care for long periods of time, and I think she struggled with a lot of things that had happened to her in life. If you review which I'm sure the court has reviewed the pre-sentence report, some very horrible things have happened to her over her lifetime. I think that she was maybe self-medicating with drugs and other things. She did get into residential treatment. She did complete that. She does recognize that using drugs is only going to cause her more trouble, but I think that the reason why she struggled so much, just the things that have happened to her in her lifetime. In the report, it notes that the incident offense is over 2 years old. I guess to her credit, she's not gotten in any additional trouble, so that's a credit to her. I've known Ms. Miller, like I said, for a long period of time. She has struggled financially. She struggled with housing. She struggled with a lot of different things, but it seems as though she's headed in the right direction. I don't disagree with the prosecuting attorney that she has definitely been involved with the court system, but the people that are using drugs, it's unfortunate to me in many ways that I do understand that there is a punishment that our legislature has rolled out, but I also recognize that there is a difference between somebody who's selling drugs and somebody who is just using them, and there's a difference between something that's mail and say and mail and prohibit them, and this is a situation where she's just making bad life choices. I don't think she's a danger to the public. I think she's probably more of a danger to herself, but the worst thing for her would be to give her a long period of incarceration, primarily because they don't want to dislodge her from her current situation. She had indicated that she's hopeful after this is all over that she would be able to move out of state and maybe recreate her life somewhere else, which I told her maybe that's in your best interest because there's a lot of baggage here, a lot of people that are difficult to get away from. And when she said that she was maybe in the wrong place at the wrong time, maybe what she was aptly trying to state is that she surrounds herself with people that continue to find themselves in similar like problems, people who have similar like issues, and it just causes her more pain and trouble. So keep that in your honor. I would just ask the court to consider something at the very low end of the guidelines with the knowledge that she wasn't selling drugs of any kind. and the incident offense is relatively old.
Ms. Miller, was there anything you wanted to say?
I realized that the last time I spoke, I think I spoke not, I didn't say the right words. I was in the wrong place at the wrong time. I chose to be where I was at, and that's why I'm standing here today, because it was my choice to be there, even though I didn't know what was really all going on. And it's something I did, at the time I'd done drugs, so I can't say that I had the best judgment calls at the time either. But I don't know, my choices led me to be on those people, which led me to that situation. It's my fault. It's my own. This is, I did. I just want all to be over with so I can do something else, be around other people that aren't like, I don't know, I seem to find myself gravitating towards you guys. Just maybe here, try to keep this over as best I can this time.
All right, thank you. I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your background based on the information in the report and prior matters as well. I think Mr. Seeger's giving you some really good advice in terms of getting out, getting away from the people that you've been around, because that situation. So I hope that you listen to what he's had to say to you. I think it's really good advice. The problem is you've got 5 felonies now on your record, more than that, actually, considering this charge. Your guidelines here are 0 to 17. The next time, really, it's going to be a prison sentence. So this is really your last chance to remain out of the prison system, because that's really where you're headed with the number of convictions that you have and the way your guidelines are going to go. So whatever it is you need to do, and again, I think Mr. Seeger's advice, getting out of town, getting out away from the people that you've been around, is a good first step. But whatever you need to do to get yourself out of this situation, you need to do if you want to avoid going to prison. In this case, I think given all the factors together, your past history, the sentence within the middle of the guidelines is an appropriate sentence to account for your past conduct as well as your conduct in this case. The court will sentence you to 6 months in the Kalkaska County Jail. You do have credit for 1 day served. Crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state costs. You do have the ability to appeal this sentence, and Mr. You.
For the record, returning a copy of our appellate rights to the court.
Thank you. No, you are remaining in custody of the county at this time. Your last file for the day.
No, I have quite the docket still, but I have to run over to Turner's court, so I'll be Thursday tonight. Also, I have to-
All right, thank you. The next case is People versus Klein. That's at 9:30, so we'll take a short recess until that time. Mr. Travis, is this Ms. Klein?
It is, Your Honor.
People versus Ashley Klein, case number 234857.
Ryan Ziegler on behalf of Plea.
Kyle Travis on behalf of Mrs. Klein.
Mr. Travis, can you tell me where we're at with this case?
Yes, Your Honor. We have this file, and I believe we've got a plea agreement. The agreement would be that Ms. Klein would plead in this file to the possession of methamphetamine under 7411. And also the prosecutor has another file that they have not yet charged that we've discussed, that if this case was resolved, that file would never be charged.
Okay, Mr. Ziegler.
Fair statement in the offer, Your Honor.
All right, Ms. Klein, can you come up to the podium? Ms. Klein, have you had a chance to talk to Mr. Travis about this plea agreement?
Yes.
Is that how you want to proceed today?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Klein, are you currently on any kind of probation or parole?
No, just out of
Okay. And have you ever been convicted of a controlled substance related offense in the past? All right. And you understand that the maximum possible penalty for this charge, which is possession of methamphetamine, is up to 10 years and or a $15,000 fine?
Yes.
With that in mind, what is your plea to that charge today?
Okay. Oh, yeah, yes, sorry. I get confused.
You're pleading guilty today?
Yes, yes.
I know I think you were probably going through your rights there. I'm going to go through those with you here as well. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yeah.
And can you tell me what's going to happen to those rights by you pleading guilty? That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you'd have to go to the next higher court called the Court of Appeals. You'd have to ask them to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we've said here in court today?
Mhm.
Is it your own free choice to plead guilty?
Yes,
Are you pleading guilty because you are guilty of this crime?
yes,
So this happened back on July 2nd of this year, is that correct?
yes,
And on July 2nd, were you here in Kalkaska County?
yes,
When you were here in Kalkaska County on that day, did you have possession of some methamphetamine? Did you know that that's what that was? Did you have any legal right to have any amount of that at that time?
No.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes.
Thank you. Ms. Klein, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Travis so that you're prepared to go forward on that day. Before you leave today, you're going to meet with Agent Barrett from probation to set up a pre-sentence interview. Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. Travis?
No, Your Honor. Thank you.
Ms. Klein, did you have any questions at all?
no, I think I was, thank you.
Okay, thank you. That's all for today.
Thank you.
Travis, are you ready with Mr. Fuller's case?
I don't see him here.
or if you have somebody else.
Don't you have anybody else?
We'll take a short recess and we'll come back on the record at 9:45. All right, Ms. Vandenberg, are you able to hear me okay?
Yes, Your Honor.
Thank you. We're on the record now in People versus Elijah Aguero, case number 234860. The record should reflect that Mr. Aguero is appearing today by video from Antrim County Jail. His counsel, Ms. Vandenberg, is appearing by Zoom, and we have the prosecutor, Mr. Ziegler, present here in the courtroom in person. This is set for a status conference today. Ms. Vandenberg, from the defense side, can you tell me where things are at with this file?
Yes, thank you, Your Honor. I had an opportunity to speak at length with Mr. Aguero, excuse me. I spoke with him when our last jury status conference, which was scheduled for and actually didn't go because the judge, or the court, I should say, gave us time to speak, and that was on Tuesday, November 7th. We spent about an hour or over an hour and just going over the files, over the discovery that we received. I also had an opportunity to speak with, I hope you can see me okay. I'm not sure if this is positioned right, so excuse my interruption. But I also, we had an opportunity, when I say we, Mr. Aguero and I this morning, to speak at around 8:15 or so from via Zoom. Your Honor, I reluctantly asked for, and I know the court was gracious enough to adjourn the last jury status conference, but I believe we're very close to a resolution. I would just need to spend some time with Mr. Ziegler. I understand that he's very busy and understaffed. So I, again, would ask the court to allow another week or two, if the court will permit, for give me some time to speak with the prosecutor, Your Honor.
All right, Mr. Ziegler.
Your Honor, this is a relatively recent case and it's also a relatively serious case. I would support the request for an adjournment to give us a little more time to try and work out a plea agreement.
Okay. All right, Ms. Vandenberg, it sounds like the prosecutor's not objecting to that. Given the nature of the case, I don't think it's unreasonable. Also, given the timing signed over here. So the court will set this for a plea hearing status conference at the court's next date, which would be in about 30 days. If we don't have a plea at that time, then Ms. Vandenberg, the court would then get it set on the trial calendar, and we would set some further dates for going forward towards trial at that time. Do you have any objection to that?
I do not, Your Honor. Thank you.
Okay, Mr. Ziegler, any objection to that?
No, Your Honor.
Okay. Mr. Aguero, have you been able to hear everything that we've said so far this morning?
Yes, sir.
Do you have any objection to what your attorney is asking for?
No, sir.
Okay. All right. So the court will send out notice of the date and time of that next hearing, and we'll go from there. Ms. Vandenberg, anything else that you wanted to address while we're on the record today?
Yes, I would just ask Mr. Ziegler at when he has some time to, maybe I can speak with his assistant to speak with him via Zoom or by phone.
If you want to call my office and arrange with my assistant the time I might be available, I'd be happy to do that.
Yes, sir.
Okay, thank you. That's all for today. And Ms. Vandenberg, you're free to disconnect at this time.
Thank you, Your Honor.
Okay. And then we'll call People versus Fuller, case number 234852.
Your Honor, is it okay if Mr. Fuller remains seated? He's got some hip problems at the moment. I think he's even
Yes.
actively being treated.
Okay. Mr. Travis, can you tell me where we're at with this file today?
Yes, Your Honor. I believe we've come to a resolution. On this matter, Mr. Fuller would plead to an attempt resisting and obstructing. And 2 files in the district court would be dismissed. One of those is an assault, the other is a domestic violence verbal. The domestic violence in the first offense and the assault is a 93-day misdemeanor assault. Those 2 files would be dismissed upon sentencing on this plea, and Mr. Fuller would like to accept that offer.
Okay, Mr. Ziegler, is that a correct statement of the offer?
It is, Your Honor.
Mr. Fuller, have you had a chance to talk to Mr. Travis about this plea agreement?
Yes, sir.
And is that how you want to go forward today?
Yes, sir.
Would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Fuller, are you currently on any kind of probation or parole?
I believe I am.
Okay,
You're on bonds,
Okay.
okay.
correct? Is that, you don't have any, other than these current charges, you don't have anything you're serving a sentence for?
No,
Okay.
All right. And you understand that the maximum penalty that you could face for attempted resisting or obstructing is up to 1 year in jail?
yes, sir.
Okay. What is your plea to that charge today?
Guilty to the attempt to resist.
Okay.
Because it was all misunderstanding.
Yeah, we'll talk about that in a second, but I want to go through your rights that you have with you, okay?
Yes, sir.
You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
You understand that you're waiving and giving up all those rights by pleading guilty.
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, just what you discussed.
Okay. Is it your own free choice to enter this plea?
Yes, sir. Well, via advisement, yes.
Sure, okay. So this happened back on July 26th. Is that the correct day?
Gosh, I don't know, sir.
Okay. Do you have any reason to doubt that that was the day that this?
No, I have no reason whatsoever.
Okay. Did you come into contact with a deputy from Kalkaska County on that day?
Well, yes.
Okay. Did you know he was a police officer?
Yes, sir.
And did you know that at that time he was performing his duties as a police officer?
Well, not at that particular time, no.
Okay.
So, Your Honor, can I ask some questions?
Sure.
So, Mr. Fuller, you had been arrested just prior to this, is that correct?
Yeah,
And you'd been in the jail, right?
right.
And you knew you weren't supposed to go back to your house as a condition of bond, right?
Well, yes and no.
Well, I'll answer that question.
Yeah,
But you had been told something about getting a half an hour to collect your belongings, is that
correct.
correct?
That's what the turnkey told me.
So you thought you had a half an hour to go home and collect your belongings?
Exactly.
But you later learned you misunderstood that, right?
Yes, sir.
You were supposed to have an officer come with you.
I didn't know that.
You didn't understand that. So then after that, law enforcement showed up at your house and you were back home, right?
Right.
And your bond condition said you weren't supposed to be there.
Correct, but I only had a half hour.
Correct.
Okay.
So you talked to the law enforcement on the porch and they told you you had to leave, correct?
No, they came to arrest me.
For violating no contact, correct?
I guess, yeah,
Okay, and you thought you were allowed to be there,
for a half hour, yeah.
and you thought they were wrong, correct?
Basically, yes.
And when they told you to come with them because you were under arrest, you didn't do that.
No, I put up a resistance, but I didn't. I finally just,
And it was mainly passive, but you made them basically drag you off the porch.
oh, yeah, and they really messed me up too, but that's neither here nor there.
So when they told you you're under arrest, you didn't listen, correct?
No, I didn't.
Okay, I believe that's a factual basis, Your Honor.
Mr. Ziegler, would you agree?
I'm satisfied, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Thank you. Mr. Fuller, the court finds that your plea is knowing, voluntary, and accurate. I'm satisfied there's a factual basis to support a finding that you are guilty of the attempt. The
Yes,
court
sir.
will accept your guilty plea. Mr. Ziegler, are the people going to be asking for jail time in this case?
Your Honor, without having run the guidelines, I can't say for certain, but I think it's unlikely.
I mean, we're at a 1-year misdemeanor based on the.
My apologies, Your Honor. No, Your Honor, I don't believe we'll be asking for jail.
Do you have any objection to proceeding with sentencing at this time?
I do not.
Mr. Travis, do you want to talk to your client about that for a second?
If I could have just a moment,
Yes.
please.
I guess, yeah. Mhm.
All right, Mr. Ziegler, on behalf of the people, anything that you wanted to say today?
Your Honor, I think the court has a pretty good understanding of the factual circumstances surrounding this case. Police went there because he was in violation of a no contact order that was in place on one of the misdemeanor files. He did not comply with the officer's commands to essentially become under arrest. When they tried to cuff him, he resisted their efforts to put the cuffs on him. There was some struggle. I don't believe he actually hit any of the officers or anything like that, but there was some resistance involved. They were eventually able to cuff him. It is concerning to me, Your Honor, that the 2 misdemeanor files that are going to be dismissed as part of this plea agreement are an assault and battery and a DV. So all 3 of these files are assaultive in nature. Normally, I wouldn't have an issue with the court just doing fines and costs on an attempt R&O, absent some, outstanding circumstances. But in this case, I think given the nature of the 3 files, I do think it would be prudent to put the defendant on a short term of probation, just to ensure that we don't have any further issues with him. So that would be my request, Your Honor, would be a short term of probation, some fines and costs. I don't think any upfront jail is appropriate in this matter.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, this is, there's quite a bit going on here. Mr. Fuller and his wife, many years. It's my understanding from speaking to Mr. Fuller and his daughter, she started to suffer from dementia. Unfortunately, an individual who has some relation to Mr. Fuller and his wife, he's the father of one of their grandchildren, had worked his way into their life. Ryan Hart, he's the alleged victim of one of these assaults. The timing of that is quite convenient to Mr. Hart. But he's gotten in the mix. He was seemingly helping them. He's now driving their cars, gotten into their bank accounts. He's had been living rent free. Mr. Fuller is a veteran and has the house that he and his wife lived in, but they had another property down the road with a trailer. Mr. Hart had been living in there rent free for some time. It just kind of was messy at the house. Mr. Fuller's doing a lot better. He's with his daughter. He's continued to be engaged with VA services. They're more involved with him and more active with his case. He indicates to me he's doing much better being out of the environment. At one point, it appears to be, from speaking to Mr. Fuller's daughter, when she started making noise about evicting Mr. Hart, magically the next day, Mr. Fuller allegedly assaulted Mr. Hart, and Mr. Fuller's kicked out of his other house. And Mr. Hart is there left, having not paid rent for Lord knows how long, in their house and driving his car. So there's a bit of a mess going on here, Your Honor. But Mr. Fuller is doing much better. He indicates he's in a much better space. Likely, he and his wife are not going to reconnect after this. At the moment, his daughter is, I think, attempting to try and get Mr. Hart out of the house and try and take appropriate steps for the wife. I think Adult Protective Services has been involved. They actually had asked Mr. Fuller if they could have permission to go on the property because they had some difficulties. And he's given them that authorization. So we're hopeful things will improve in that situation. I'm not there on the ground, but by all appearances, it appears as though a group of individuals are taking advantage of Mr. Fuller's wife and her dementia and the fact that she has property and resources and are able to basically be living rent-free on her properties and driving their cars. I just say all this because this is a little bit messier than it seems. But Mr. Fuller is doing quite well. Mr. Fuller understands that what he did with the officers was inappropriate. He understands he was mistaken. He's here, he was here to plead to that. He, happily is doing that. So he does have a lot of resources. So if the court feels probation is appropriate, and that is acceptable, but there are a lot of folks involved. I personally, knowing what's going on, think that Mr. Hart and the group of individuals he's brought into the property are the folks who need to be removed from the situation. And then probably, given what I'm hearing, that Mr. Fuller isn't really capable of taking care of his wife in her current situation, that they probably do need to not come back together and just be the two of them at the end of this. And it sounds like his daughter has escalated her involvement and is trying her best. Thank you, Your Honor.
Thank you. Mr. Fuller, was there anything you wanted to say today?
Okay. Pardon me, sir. I'm sorry.
Was there anything you wanted to say today?
Oh. Nothing but my house is overwhelmed with these freeloaders. And I really don't know how to get them out. I mean, they're sleeping in my bed, they're wearing my clothes, they drive my car. And so I'm gonna give the car to her. Oh. And I apologize for being the way I was with those officers. It was a total misunderstanding. Because I was told here at the bailiff that I had a half hour to get there, get my stuff and leave. So in my mind, that's what I thought I had. And I would never resist an officer, not intentionally. I'm pretty honest, I'm real honest, and I wouldn't do that normally, but I was misinformed. So I thought I had my right to be there for a half hour. They were there within 15 minutes.
Okay. All right. I've had a chance to listen to kind of both sides of this. And I think I agree that jail time isn't appropriate. It sounds like, Mr. Fuller, that generally you're not, a danger to just the community. It sounds like this is a very specific situation. The only thing I would say is, number one, with regard to whatever's happening at your home, the right way to deal with that is not to go hands-on. The right way to deal with that is to get the police and the court involved and let that process take care of the problem instead of you doing it yourself. And then, with regard to the police and the misunderstanding of you going there, the best thing to do is listen to what the police say. You can, if you think they're wrong, there's ways to challenge that later. But again, resisting is not the legal way to do that, to remedy that problem. You can always take care of it later. The prudent thing to do is do what the police officers are saying at the time. If you think they're wrong, maybe they are, they're not perfect.
Right.
But the way to take care of that is later on, not at the time. So I think that I don't feel that probation is appropriate. I think the right way to deal with this is to impose some fines and costs rather than jail time or probation. So the court is going to impose a crime victims assessment of $75, a $50 state cost. Mr. Travis, are you appointed in this case?
Yes, Your Honor.
Court appointed attorney fee of $350 and court costs of $325. Did Mr. Fuller spend any time in jail?
I think he spent not a lot of time. He's generally been in and out, but I think
No, on this case.
Yes, no, I think there was an overnight.
One day of credit.
I wouldn't disagree with that, Your Honor. He was arrested at the time that he resisted.
Okay, so the court will impose 1 day in jail with credit for 1 day served. Mr. Fuller, you do have the right to appeal this sentence. If you wanted to appeal it, you would have to file that appeal within the next 21 days. If you had other questions about that, Mr. Travis, I'm sure could answer those questions about the appeal. Otherwise, when you leave the courtroom today, go across the hallway to the clerk's office and they'll make arrangements for you to pay the fines and costs, okay?
I don't have the money just to.
Yeah, they'll make arrangements for you to get those paid off, okay?
Okay, great.
All right.
And I do apologize.
And I'm sure the officers we'll appreciate that. Yeah. Mr. Ziegler, anything further on this case today?
No, Your Honor.
Mr. Travis?
Nothing further, thank you.
Thank you, Mr. Fuller. That's all for today.
Thank you, sir.
Mr. Travis, Mr. Kittle is next at the set for 10.
Gentlemen.
Sir, what's your name?
Mr.
McGuire. Are you ready on that, please?
Yes, sir. I do think so.
Mr. McGuire, if you want to come forward, the court will call People versus McGuire, case number 234847. The record should reflect Mr. McGuire's presence here in the courtroom. If I could have counsel put your appearances on.
Right. Yeah.
Thank you, Your Honor. Kyle Travis on behalf of Mr. McGuire.
Thank you. Mr. Travis, how did we want to proceed today?
So, Your Honor, we had adjourned this because of the referral made for Mr. McGuire to be reviewed for sobriety court. And looking at what's happened, Mr. McGuire reached out to me and he hadn't heard anything, and I directed him towards Ms. Gomez. Talked to kind of went through his information. So I asked the referral been made, everything's there. Spoke to Ms. Wagner from MDOC, she inquired, and basically to the extent we understand is it's just he hasn't been accepted yet. It's not that he's been denied. We're not quite sure where we're at, but it's not a denial, but we can't come to the honor until he's been accepted. So we would ask if we could have another adjournment to try and figure out what has happened.
Mr. Ziegler, can you shed any light on where things are at in the sobriety court? And
Your Honor, I haven't heard anything from Ms. Gomez. I've missed the last couple sobriety court meetings due to understaffing. I do have one this afternoon, which I plan to attend. So hopefully I'll be able to clear this up with Ms. Gomez this afternoon.
okay, Mr. yeah,
I did reach out to her yesterday as well, so she has my number and everything as well.
okay. All right, the court will set this for one more hearing in about 30 days if we don't have further movement from sobriety court at that time, then we'll need to move forward with the file one way or the other. Mr. Travis, okay. So Mr. McGuire, continue to communicate with your attorney, and to the extent that Ms. Gomez needs information from you.
Yes, sir.
To do that.
Absolutely.
And then of course abide by all the conditions of your bond.
Yes, sir.
We'll be back in about 30 days.
Yes, sir. Thank you, sir.
Thank you, Your Honor.
All right, we'll call People versus Buck Hittle, case number 234859. If I could have counsel put your appearances on.
Ryan Ziegler, we have to be here.
Kyle Travis on behalf of Mr. Hittle.
Just looking at my notes, Mr. Hittle failed to appear back in November. He was required to bring to appear today in person and to bring medical documents for, I guess, why he didn't appear back in November. This was set for 10 o'clock. It's now 10 after 10. Mr. Hittle does not appear to be in the courtroom. I don't see anybody connecting on Zoom. Have you had any contact with him, Mr. Travis?
That day he was trying to Zoom in and indicating he had COVID. I may have spoken to him in the day after that or around there, Your Honor. But recently I haven't. I specifically tried to call him a couple times, and the last number he used, I will indicate in dealing with Mr. Hittle, and in this case, I'm on like phone number 3. So I'm not terribly shocked that the most recent number wasn't working. But no, in the days leading up to this hearing, I have not had contact.
Mr. Ziegler, did people take any position on this?
Your Honor, the court is probably aware, but this is a fairly old case. It's from back in 2020. The reason for that is that a bench warrant had to be issued, and at least September of 2020 for Mr. Hiddle's failure to appear. He was just brought back before the court in August of 2023. So this is not his first failure to appear. I would ask the court to issue a warrant for his arrest.
Okay, just looking at the file and based on the statements of both counsel here on the record, I think it's more than appropriate, given Mr. Hiddle's history in this case. Mr. Ziegler's correct. It looks like the court issued a warrant back in September of 2020 for this failure to appear. And then now this is his third failure to appear. So the court's going to order that his bond be revoked. The court will request that the prosecutor prepare a bench warrant for his arrest. The court will order that Mr. Hiddle be held without bond once he is arrested. And then once he's apprehended, the court will set it for a status conference at the next available date following that. Anything further on this, Mr. Ziegler?
No, Your Honor.
Mr. Travis?
No, Your Honor, thank you.
And then the next hearing is Mr. Morris, 15. We're a little early. Have you had any contact with him?
Your Honor, it's my understanding he's in custody. That's actually one that I'm going to cover it for Mr. Horowitz. It lists as my name, but Mr. Horowitz had actually took a file over
Okay.
from me, but I think if he's available, talk with Mr. Horowitz and Mr. Ziegler, and I think I know where we're headed with it.
Okay. I don't see them signed in yet, so.
I think he was physically brought over. Was it? No? Oh, okay.
Okay. So we'll see. I'm not sure. Do we know where he's at?
Wexford is my understanding. Actually, when I spoke with Mr. Horowitz, I think he zoomed with him yesterday. Wexford.
Okay. So we'll wait a couple minutes to see if Wexford signs in with him. Okay, sir, are you Timothy Morris?
I am, sir.
Okay, thank you. We're on the record in People versus Timothy Junior Render Morris, case number 234863. The record should reflect Mr. Morris is present today by video from Wexford County Jail. If I could have counsel put your appearances on.
Ryan Ziegler, yeah, people, Your Honor.
Kyle Travis, for Mr. Under Morris today, filling in for Mike Horowitz, his attorney, record.
Thank you. Mr. Travis, have you had a chance to talk to Mr. Morris about how he wants to proceed today?
I didn't speak with him directly, but I did speak with Mr. Horowitz, who I think had just spoken with him yesterday. It's my understanding that the parties were going to be asking for an adjournment because there are more charges coming. And because of those charges, there hasn't been a plea offer made. So basically the parties want to get everything on the table and then have plea discussions.
Okay. Mr. Ziegler?
Your Honor, I'm working on getting a number of reports from the sheriff's department regarding some mostly larceny charges. I'm hopeful to have those in the next 30 to 45 days and get all those charges filed in the district. I'm not sure how many will be filed, but there are numerous cases that we're looking into in terms of larcenies. So I would just ask, it's our first appearance in circuit court. I would ask the court to give us at least 30 days adjournment.
Okay. Mr. Morris, were you able to hear all of that?
Yes, sir.
Okay. And were you able to talk about that with your attorney, Mr. Horowitz, yesterday?
Yes, sir. I agree with that.
Okay. The court will then set this for a status conference. And at that time, hopefully we'll have all the charges and the parties will have been able to discuss a global resolution. Mr. Travis, anything else that we need to address today?
Not that I'm aware of, no.
Mr. Ziegler?
No, Your Honor.
Mr. Morris, did you have any questions at all?
No, sir.
Okay, thank you. So Mr. Horowitz, your lawyer should be in touch with you once those additional charges are filed to discuss any plea offers from the prosecutor. And then we'll have another hearing following that. And the court's going to go ahead and disconnect at this time.
Thank you, sir.
Mr. Seeger, were you ready with Ms. Healy?
Yes, sir.
Okay. People versus Jennifer Healy, case number 234851. The record should reflect Ms. Healy's today. I could have counsel with your appearances on.
Ryan Ziegler, yeah, people, Your Honor.
Thomas Seeger, praying with my behalf of Ms. Keeley.
Mr. Seeger, how did you want to proceed today?
Your Honor, it's my understanding that people have offered Ms. Keeley an opportunity to plead to an egg into a possession of narcotics. 4-year felony in exchange count 1 would be dismissed.
Fair statement of the offer, Your Honor.
Okay. Ms. Keeley, have you had a chance to talk to Mr. Seeger about this plea?
I have,
And is that how you wanted to proceed today?
yes.
Okay. Mr. Ziegler, do you have the fact code for that added count too? So
333-7403. 2 A is in Adam 5.
thank you. And are we taking the factual basis to possession of cocaine?
Yes, Your Honor.
Okay. Ms. Keeley, could you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. Keeley, are you currently on any kind of probation or parole? All right, and you understand that by pleading guilty to this added count 2, which is possession of narcotics, the maximum penalty you could face would be up to 4 years.
Correct.
With that in mind, what is your plea to that charge?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
I do.
And you understand that you're giving up and waiving all those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you'd have to ask the next higher court, the Court of Appeals, to hear that appeal. They could say no, and then that would be the end of your case. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've discussed here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
So this, the information indicates that this happened back on July 27th of 2023, is that correct?
Correct.
On that day, were you here in Kalkaska County?
I was.
And while you were here in Kalkaska County, did you have possession of some cocaine?
I did.
And did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of that at that time?
No.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Ms. Keely, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, it's important that you stay in touch with Mr. Seeger so that you're ready to proceed on that date.
Okay.
And then before you leave today, you're going to meet with Agent Vera, set up a pre-sentence interview.
Okay.
Mr. Ziegler, anything further on this file today?
There you are.
Mr. Seeger.
No, sir.
Okay, Ms. Keely, that's all for today. Thank you.
Mr. Smith?
Yes. Right around the table, standing up here.
Court calls People versus Gregory Smith, case number 234849. The record should reflect Mr. Smith is present here in the courtroom today.
Ryan Ziegler, I'm yes, people, Your Honor.
Thomas Seeger, bearing with me on behalf.
Mr. Seeger, can you tell me where things are at with this case?
Your Honor, it's my understanding that the people have offered Mr. Smith an opportunity to plead to count 1 and exchange count 2 and count 3, and the habitual offender 4th notice would be dismissed. Additionally, Your Honor, any restitution is duly outstanding relative to this.
Everything in the offer, Your Honor.
Mr. Smith, have you had a chance to talk to Mr. Seeger about this plea agreement?
Oh, yes, I have.
And is that how you wanted to proceed today?
Yes, I do.
Okay. Could you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Smith, are you currently on any kind of probation or parole?
No, I'm not.
And you understand that the maximum penalty you could face for count 1, which is uttering and publishing, is up to 14 years.
Yes.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, I do.
Can you tell me what's going to happen to those rights by you pleading guilty?
By pleading, my rights will be rescinded.
That's correct. You'll be waiving them and giving them up.
Correct.
Okay. Also, you don't have an automatic right to appeal the plea that you're making here today.
Okay.
If you wanted to try to do that, you'd have to go to the next higher court, which is the Court of Appeals. You'd have to ask them to hear your appeal. They could say no, and then that would be the end of that case. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said here in court today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are guilty?
yes.
Okay, so, on or about January 13th of 2023, did you write a check that was gonna be drawn by Huntington Bank?
Yes, I did. I didn't write it. It was a company that used a check protector,
Okay,
put my name on it.
okay, gotcha. Did you forge the signature of someone else to be able to cash that?
Yes, I did.
Okay. And did that take place here in Kalkaska County?
Yes, it did.
Mr. Seeger, did you have any additional questions?
No, Your
Mr. Ziegler?
I think for our publishing, it needs to be established that that was a true document in order to defraud someone.
Okay, I mean, was your purpose, Mr. Smith, in forging that signature and attempting to cash that check? I mean, we knew that you didn't have the right to the money that you would get from that check.
Oh, correct.
Okay, and you did that for the purpose of obtaining that money?
Yes, I did.
All right, Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, you're not.
Mr. Seeger,
Yes, Your Honor.
are you aware of any threats, promises, or inducements?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor. Yes, sir.
Mr. Smith, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. And then you'll also meet with somebody from probation to do a pre-sentence investigation. Mr. Ziegler, anything further we need to address today?
No, Your Honor.
Mr. Seeger?
No, sir.
Okay, thank you. That's all for today, Mr. Smith.
Thank you.
We have.
Mr. Iles, were you here on Mr. May's case?
No, Your Honor, I believe we adjourned that.
Yeah.
Because we're still awaiting the results of the vote on sobriety court.
Okay, I just wanted to make sure you were aware that we did it or not.
Just here trying to learn by watching the Masters at the front of the room.
Sounds good. Who did we have?
Mr. Inman.
Okay, were you ready on Mr. Inman?
I am here.
Okay. We're on the record in People versus Joshua Inman, case number 234853 and 234854. The record should reflect Mr. Inman is present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler, we have two people, Your Honor.
This is the date and time set for sentencing. Mr. Inman, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, Your Honor.
Okay. Mr. Seeger, are there any additions, deletions, or corrections?
Sure, I'm not sure what happened. It may have been my error. It may have been written down wrong, or I may have presented to you or presented it to the court incorrectly. In any event, Your Honor, the file should be inverted. So 4853, the plea should have been to domestic violence as an attempt. And then 4854 should have been the assault battery. I did talk to the probation department about it, and they changed the scoring to reflect that, but the body of the report still reflects the way that either the court took the plea or if it was understood, but they should be switched in terms of what file falls under what plea.
Mr. Ziegler?
Your Honor, I have no objection to the check. The court motion to enter the plea. I believe believe that this is the way it's entered. But if the defense, for whatever reason, wishes to have it reflect the other way, that people would have no objection to that.
So, yeah, I mean, I don't recall that, you know, which file was which from the plea hearing. I think if we have a stipulation, I don't have a problem amending the record to reflect. Do you want the file 234853 to be a plea to attempted domestic violence third offense?
Correct, Your Honor.
And then 4854 would be the plea to the assault and battery.
Correct, Your Honor. And then the sentencing guidelines may have been marginally different had it been the way that it's presented currently, but then speaking with the probation department, they amended the scoring of the guidelines to reflect the other way around.
Okay. So the court will order that be changed for the record, so we may have to.
Yeah, I'll have to flip those around. I think the charges are right. It's just on the.
Oh, yeah, okay. All right, any other corrections, Mr. Seeger?
Your Honor, and then just in the pre-sentence report itself, it would, there would just have to be some small changes just to reflect that.
To reflect that, okay,
Yes, Your Honor.
okay. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, did the people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring of the guidelines?
No, Your Honor.
Anything on behalf of the people for allocution today?
Again, I think probation parole done a good job of laying everything out. I agree with the recommendations of probation and parole. Obviously, on the assault and battery charge, he's already served more than enough time for that file. In terms of the domestic violence third offense, I agree with the recommendation that there should be some upfront jail followed by a term of probation. It sounds like Mr. Inman is remorseful and that he's willing to take some steps to get his life back in order. I'm glad to see it. This is Mr. Inman's first felony offense, so while he has had numerous misdemeanors in the past, I believe on some of those misdemeanors, he's had the opportunity for probation in the past. I do agree that he should be given that opportunity in this case. The only question in my mind, Your Honor, is what to do in terms of any jail up front or jail in advance. Mr. Inman has already served 106 days of jail. I think that the nature of the offense, especially given the fact that there were 2 domestic violence thirds over a very short period of time, suggests that there should be some jail up front. But whether the court feels that there needs to be additional jail up front or whether the 106 days up front is sufficient, I would support the court placing him on a period of probation following that and holding some jail in advance to make sure that he has every motivation to comply with the terms of probation and help correct the issues that have plagued in the past. Thank you.
Mr. Seeger?
Your Honor, likewise, I would just ask the court, if the court was going to give him further amount of jail, I would just ask the court consider placing it in advance. Mr. Inman has made a remarkable improvement since he's been incarcerated. When I first had interacted with Mr. Inman, he was somewhat defiant. I think he was struggling with, some substance abuse problems. He was struggling with his family life, and he was trying to correct some of those things. As time went on, he became more remorseful for the things that he had done. He had a better understanding of how he put himself in this situation. While incarcerated, he's tried to get into treatment, which he recognizes probably being the larger part of his problem. I have talked to his family members, not the son, but his, I'm not sure, the former Mrs. And she's expressed that she wanted him to get into substance abuse treatment. She sees that as a larger problem for him. And I think Mr. Inman did not recognize or was unwilling to recognize that he had a very serious substance abuse problem that was causing him a lot of grief. But since then, he's tried to get into treatment. He had a bed available to him at one point in time. At the time of the plea, he had asked to get into treatment. The court said that it would conceivably reconsider it at the time of sentencing. And so hopefully this will be a opportunity for him to correct some of the issues that he has going on in his life. In terms of the facts and circumstances of the case itself, neither one of them are good because all of them are domestic violences. But there was a case somewhat recently wherein somebody received a very stern sentence, but that particular case, albeit it was domestic violence third, also included, the breaking of bones and things of that nature was quite serious in terms of what allegedly happened. In this particular case, it was a lot of pushing and shoving. I think had he not been drinking in either one of those situations, it probably wouldn't have ended that way. The one with the son, some things were said and it probably just got out of line. And then there was another instance with his former roommate, which they were going their separate ways, and that ended poorly as well. But in either event, Your Honor, he is remorseful. He wants to get treatment, and I think the underlying problem for him is his substance abuse problem, which is Mrs. has expressed a great want and much happiness that he's at least addressing it, because I think formerly he was not addressing it. It was just causing lots of problems for him and the family collectively. So to that end, Your Honor, I would just ask the court to consider holding any time in advance to allow him to get into treatment, because that's really what he wants to do.
All right, thank you. Mr. Inman, anything that you wanted to say today?
Yes, I do. Forgive me for being nervous. I just want to say that with the time that I have, I've read some books. I've read the Alcoholics Anonymous book, and I realized I take full responsibility for my actions. And that I realized in the beginning I was shameful of being an alcoholic. And now I know it's okay to admit that I'm an alcoholic, that I'm going to seek treatment and, let people know that I'm an alcoholic, and that I know that was my biggest problem, was just being shameful and embarrassed of it. And just like I said, I take full responsibilities in my actions. And I just like to thank Mr. Barrett and Mr. Ziegler for this, and Mr. Seeger for this opportunity, because I know chances don't come around like this all the time. So I'm just very thankful for the time that I had, because I have learned a lot about myself and why I've done the things I've done. So I'm not ashamed of it anymore. I can stand up and actually say I'm not ashamed of being an alcoholic, because that's my first step of just admitting to other people. I know if I seek help, I do good, I will get help from others. And spiritually, I have been reading a lot with, the Bible and all that stuff. And I'm realizing the stories in the Alcoholics Anonymous books reflected a lot about things I've done. And I just realized that with my family and friends and my employer still supporting me, that I have a good chance. And with this time, how much time it's taken for me to feel this good and have my confidence back, I don't want to lose it. I don't. I know it's something that I don't, because how much time it's taken, it's to feel this good. I'm proud of myself, and I'm just thankful for everybody that has said the nice and kind things about me.
All right, thank you. I did read through the report, so I'm familiar with the circumstances in these two incidents, as well as just your general past history. There's a lot of information in there about that. But I take all of that into consideration, along with what yourself and the lawyers had to say here today, and looking at what can we do to address not only what your actions in this case, these two cases, but what can we do in terms of rehabilitation going forward? And I think there needs to be a combination of punishment and consequence, so we understand that there are consequences when you behave in this way, whether it's caused by alcohol or not, but also provide the opportunity for you to continue on this path. It sounds like you started in terms of addressing that problem. And I agree that that probably would go a long way to preventing this type of incident from happening again. So I think a sentence that incorporates those two things is appropriate. You've already served 106 days. In my view, that's a good consequence up front. It's direct. I think it's provided an impression for you. And then I think there also needs to be some time held over your head, as the prosecutor suggested, so that if you don't comply with the probation, there's an additional consequence that will occur immediately if you violate your probation. Pardon me. So as to file number 234853 and the charge of domestic violence third attempt, the court is going to place you on probation for a period of 18 months. The court is going to adopt as the conditions of your probation in that file, all the terms and conditions listed in the report, which of course is that you not use or possess any alcoholic beverages or other intoxicants, that you participate in and complete any treatment programs that are recommended to you. And regardless of whether it's recommended, I hope that you do pursue treatment for the alcohol. I think the incident with your son, from what I read, I think there's a lot of repair that's going to need to happen to that relationship. And I think if your son is willing, to the extent that the two of you can participate in some therapy together, it would go a long way towards repairing that relationship. I think that's going to take time based on what I read in the report. That's not going to happen overnight. I think you need to realize that, but I think that's something that you're going to need some help with, and it's not something that you're going to be able to do on your own effectively. So to the extent that you can participate in some therapy with him as part of your probation, I think that would be helpful as well. And all the other terms and conditions listed in that report. The court is going to impose 9 months in the Kalkaska County Jail. The court's going to order that you serve 106 days of that up front with credit for 106 days served. The court's going to hold the remainder of that time in abeyance. So if you successfully complete your probation, you won't ever have to serve the rest of that time. If you do violate your probation, though, the court can order that you serve that time immediately without any hearings or anything. Just do not pass go, straight to jail for the rest of the 9 months. The court is going to order crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, a state cost of $68, and a supervision fee while you're on probation of $30 per month. The court is going to incorporate paragraph 14, which is a no contact order with your son. However, the court is going to add a provision in there unless approved by your probation agent. So that's something I'm going to leave to between you and your agent. It sounds like things are going well, or it sounds like you're going to participate in some therapy, then your agent can allow that contact as needed. But you need to make sure that you get it approved with your agent before you do anything like that. As to file number 23454, which is going to be the charge of assault and battery, 106 days in the Kalkaska County Jail with credit for 106 days served. Crime victims assessment of $130. I'm sorry, 93 days in the Kalkaska County Jail with credit for 93 days served. Also a crime victims assessment of $130. The court is not going to assess separate court costs or attorney fees as to that file, but a $53 state cost. You do have the ability to appeal the sentence, and Mr. Seeger, you can have Mr. Inman acknowledge Seeger those appellate rights. Just for the felony.
The only thing that would only because he asked, Your Honor, the no contact with his son, which he told by as a condition of his probation, but for the record, that file is resolved in as much as closed. So the misdemeanor is related to his son. I'm not saying that you can't do something else with condition of probation, but just so clear, Mr. Inman, it's still a condition of probation.
Correct. Oh, right.
Okay.
Yeah.
Thank you.
Okay. Okay. Thank you. Good luck to you, Mr. Inman.
Thank you.
Appellate rights have been returned.
Thank you.
I just have a moment to call Mr. Brown, who also represents Mr. Antoine. This is his call, so I don't think that's something that they.
Yeah, we're a little bit ahead of schedule, so we'll take care of that attendance rate. We're on the record in People versus Matthew Antoine, case number 234867. The record should reflect the defendant present here in the courtroom. I get counsel.
Brian Ziegler, on behalf of Chief
Secret opinion, can I get Antoine?
Thank you. How do we want to proceed? Mr. Speaker?
Your Honor, it's my understanding that Mr. Antoine is the defendant of count 1 and count 2 will be dismissed.
Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Antoine, have you had a chance to talk to Mr. Seeger about this plea agreement?
Yes,
Okay. Is that how you wanted to proceed today?
yes,
If you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, sir.
Mr. Antoine, are you currently on any kind of probation or parole? No. You understand that the maximum possible penalty you could face for count 1, which is delivery or manufacture of methamphetamine, is up to 20 years and or a $25,000 fine.
Yes, sir.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
So right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
And can you tell me what's going to happen to those rights by you pleading guilty today?
Give them up.
That's right, you'd be waiving them and giving them up. Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to do that, you'd have to ask the next higher court up, the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
This happened on June 13th of 2023. Is that about the correct date?
Yes, sir.
Okay. On that date, were you here in Kalkaska County?
I was in Rapid City County.
Okay, Rapid City.
Yes.
Okay. And when you were in Rapid City back in June of this year, did you have possession of some methamphetamine?
Yes, sir.
And did you know that that's what that was?
Yes, sir.
Did you give or sell that to another person?
Yes, sir.
Did you have any legal right to do that at that time?
No, sir.
Mr. Ziegler, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Speaker?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Antoine, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of count 1. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, you'll meet with the probation department for a pre-sentence report. Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. Seeger?
Your Honor, I would just note that this is been done for the probation department. It's outstanding. I'm not sure if you're the judge that's handling that matter, but it's set for Thursday. So come up here in court of Judge Hunter.
That would be Judge Hunter.
So I don't know if the probation departments want to coordinate with each other to the extent they accept the plea over there.
Okay. All right, thank you. That's all for today, Mr. Antoine.
Thank you.
Yes. All right, our next hearing set for 11:15. We'll take a short recess until that time. Cummins right at the podium there.
Okay.
We're on the record in People versus Travis Cummins case number 224647. The record should reflect Mr. Cummins is present here in the courtroom. If I could have what your appearance is on.
Travis on behalf of Mr. Cummins.
Time set for sentencing in this matter. Mr. Cummins, did you have a chance to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, Your Honor.
Mr. Travis, are there any additions, deletions, or corrections?
Yes, Sharon, I have an email, a copy of an email that if I could give it to the court, it's kind of related to some of the issues I would raise. So the, I guess, challenge, and I don't necessarily know that what's put in the report is inaccurate, but it does appear something happened with the warrant in this case for Mr. Cummins. Mr. Cummins had contacted me a couple months ago about turning himself in and indicates, and as near as I can tell that this did happen, he came here, they didn't have a warrant on me, and they didn't arrest him. And what I gave the court there is an email from jail staff in Grand Traverse County indicating that he was in the jail in Grand Traverse County on those days. And I've spoken with his attorney over there, Mr. Graff, and apparently he was directed to try and turn himself in as part of the probation. He was also, just prior to being in jail there on 9/20, he was in Crawford County for a day or two before he went to Grand Traverse. So something happened and the warrant here was not in lien. Mr. Cummins initially tried to turn himself in on this case, then ended up back in Grand Traverse County, briefly in Crawford County for a day or two. But I guess my argument would be that he should get some more days of credit. I think that technically should be 13, even though it shows more, because it looks like he went into Grand Traverse County on 9/20. Maybe potentially a day or two in Crawford County, so maybe 15. It appears as though on 10/3 he was sentenced on a probation violation in Grand Traverse County. I think Ms. Wagner would argue after he was sentenced, he's not entitled to credit anymore. But from 9/20 to 10/3, had the warrant been active, he would have gotten credit for that time. And so there's two points I guess I want to point out. One, even though Mr. Cummins didn't show up at his sentencing, he did try and turn himself in, that the jail just wouldn't take him. And two, I think that is somewhat supported by the fact that I know he was in jail in Crawford. I clearly know he was in jail in Grand Traverse, and there isn't credit. There appeared to be something that I can't figure out because I asked jail staff, and well, can you tell me when the warrant was in lien, when it wasn't? They can't really come back and pull that out and tell me when it was, when it wasn't. So that's basically my explanation / request for more days of jail credit. I would ask for him to get anywhere from 13 to 15 additional days of jail credit.
All right, thank you, Mr. Ziegler.
Your Honor, factually, I don't disagree with anything Mr. Travis is saying. It sounds like we had issued a warrant, but for whatever reason, it was not properly entered into lien, or a hold was not marked on it. And so technically there was no hold on him at the times he was incarcerated. So I believe legally he's not entitled to that credit. I would support the court taking those days that he served into account, giving him some kind of fictive credit. But I think legally speaking, because the hold was not in place, even though that was on our side and not the fault of the defendant in any way, he's technically not entitled to that credit. So I don't think the PSI is inaccurate, but I would support the court taking that into account.
Okay, understood. So I think Mr. Ziegler is probably correct that from a legal standpoint, there's not a right to that credit, so the court isn't going to alter the PSI. However, I do think it's fair, since the error was not on Mr. Cummins, to consider giving him credit for that additional 15 days. So I may grant that credit as part of the sentencing, but I don't think it's something that should be corrected in the PSI. Any other corrections?
No other corrections, Your Honor.
Okay. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
I think probation parole's batting 3 for 3 today. I agree with everything in PSI. I support the recommendations. I think there have been some issues with Mr. Cummins on bond and with his appearance report. I don't think he's a good candidate for probation. I would ask the court to sentence him to 3 months jail and give him whatever actual credit he's entitled to, as well as whatever fictive credit the court believes he's deserving of by virtue of the error and not putting a hold on him.
Thank you. Mr. Travis.
Thank you, Your Honor. Your Honor, obviously, Mr. Cummins has had some struggles. He's not picked up anything too terribly serious, but he's got a couple misdemeanors out there. He ended up being sentenced to 93 days and serving that with good time in Grand Traverse County during the pendency of this case. So even though arguably he was under sentence for a portion of that, he's been in jail since about 9/17 before as he comes before Your Honor. He's been incarcerated since mid-September. He understands that he needs help. In a little bit of explanation and as to what happened here, and it's not really complete, but I did get a chance to speak with Mr. Cummins' mother. Obviously, she's familiar with him. She said in the period after this happened and before recent times when he's tried to take care of what he needs to do and wanted to get his life back on track, it wasn't necessarily that he was doing drugs or running around doing illegal things. She indicated that she was very concerned that his mental health was not in a good spot and she'd never seen him in such a bad state. And he was dealing with quite a level of paranoia. He has taken some steps. He's attended some sessions with CMH. He is open to continuing to do that. And he has a good relationship with his mother and she's very concerned with him, for him. So, and him and I talked about that. I think I wouldn't take this as sometimes the typical, particularly in a drug cases, I just want to go use drugs. I don't want to deal with reality. I think Mr. Cummins was having some other struggles that caused him to make some poor decisions. So we would ask the court to actually consider a time served sentence, or if not, maybe just another couple, whatever the court feels appropriate. Thank you.
All right, thank you. Mr. Cummins, was there anything that you wanted to say today?
No, Your Honor, other than I'm sorry for not showing up.
All right, I did read through the report, so I'm familiar with what happened regarding the charges here, as well as some background information on you as well.
Mm-hmm.
And taking all of that into consideration, along with what everyone's had to say here on the record. I do think a consideration both of your behavior in this case, as well as since the plea was entered back in May of 2022, and looking at the guidelines in this case, I do think a sentence of 90 days is appropriate. I think that provides a degree of punishment and consequences for you, not only for your behavior in this case, but your absconding behavior as well. I do think that although you're not legally entitled to it, that it is fair to grant you credit for the mistake in the paperwork. Although, when you have trouble across different counties, it creates a mess of paperwork. And frankly, I'm surprised at how often everything ends up correct, given the number of different agencies involved, the number of different county governments involved. And so when you get yourself in trouble in multiple jurisdictions, you kind of bear the burden of doing that. And part of that is trying to track all the paperwork. But I do think it is fair to give you credit for that time that you otherwise would have gotten credit for, which is an additional 15 days. So the court is going to sentence you to the Kalkaska County Jail for a period of 90 days. You do have credit for 33 days served, a DNA testing fee of $60, a $68 state cost for crime victims assessment of $130, court costs of $325, attorney fees of $350 and a fine of $250. You do have the ability to appeal the sentence. We're going to provide you with some paperwork that explains what your appellate rights are, as well as how to request an appeal or a lawyer to help you with an appeal. And Travis, if you could just let us know or let me know when Mr. Cummins does receive those appellate rights.
Okay.
You already made it to the custody of the county at this time. Last case we have on the docket this morning is People versus Household, case number 234824. That is an in-person hearing at 11:15. Now 11:30. That is the defense or defense counsel's present here in the courtroom. Had any contact with counsel in that case?
I have not, Your Honor, nor have I received a copy of the criminal responsibility exam in this case.
We have an order out there for that.
Your Honor, we've been adjourning. My recollection is that we received a competency evaluation in May. We're still waiting for criminal responsibility at that time. We've been adjourning this case pretty much in order to wait for that criminal responsibility exam to come back.
It looks like there was at one point a bench warrant, but it looks like maybe that was recalled. Okay, all right. Any input, Mr. Ziegler, from the people as to how to proceed?
Your Honor, given that we would likely be adjourning for the criminal responsibility anyway, and I don't know why defense counsel is not present, I assume that there was an error on his part. Maybe one thing if the defendant just failed to appear, but I would ask the court to issue a show cause and try and get to the bottom of why both defendant and defense counsel have not appeared today.
Okay. The court will set this for a show cause hearing in January and status conference. And we'll just note for the record that defendant or defense counsel appeared today. That concludes our morning docket. Court will be in recess until 1:30.